right, good afternoon. Welcome to the November 15th meeting of the Committee to Review and Assess Zoning and Review the Town's Use of Regulatory Agreements. I'd like to start by reading the Mass General Law Statement. This meeting is being recorded and will be rebroadcast on the Town of Barnstable's Government Access Channel. In accordance with Massachusetts General Laws, Chapter 30A, Section 20, the Chair must inquire whether anyone else is recording this meeting, and if so, to make their presence known. Seeing none, this meeting will be replayed via Xfinity Channel 8 or High Definition Channel 1072. It may also be accessed via the Government Access Channel live video on demand archives on the Town of Barnstable's website. Turn it over to Cynthia to do roll call.
Members of the committee: Catherine Ledeck. Chair of Committee Bob Schulte.
Here.
Ken Alsman.
Here.
Councilor Jeff Mendez. Councilor John Crow.
Here.
Councilor Matthew Levesque. Councilor Kristen Turkelson.
Here.
Councilor Charlie Bloom.
Here.
Seth Etienne. You have quorum.
Thank you. Start by reading the purpose of the committee, which is to work with the town's planning and development staff to review and reassess recently adopted zoning changes, review the town's use of regulatory agreements, and make recommendations to the council. I'd like to start with a quick introduction. I want to thank everyone for joining us today, both in person and via Zoom. I understand we have one person via Zoom today. We continue to have significant interest in the work of this committee from members of the public, and I want to thank everyone who's taken the time to either attend or write to the committee, and I encourage people to continue to do so. I'd like to remind everyone that comments to the committee can be provided in person, via Zoom, or by email. Email comments should be sent to Cynthia Lovell's attention at Cynthia, CYNTHIA, .Lovell, LOVELL, at town.barnstable.ma.us. Please note in the subject line, ad hoc committee zoning comment, and Cynthia will forward all email comments to each of the committee members. A few housekeeping items just wanted to cover. First, I'd like to mention that Kristen and I met with Jim last Saturday morning. Took a walk around the downtown area. We got lucky. It was sunny, a little breezy, but a nice day. Jim was able to provide us with a first-hand look at the parking situation, as well as some of the sites where there's current and potential development planned. I think it was well worth the time, and I want to thank Jim for taking time out of his weekend to do that. And I think Jim said he would still be happy to do that with anyone else. If you're interested in taking the tour, just reach out to him. Again, I think it was really good, kind of along what Ken had recommended last time, kind of a boots on the ground, walk down Main Street. And I learned a lot, not just about the parking, but seeing where some of the things that have been approved that are going, and other things that are kind of in discussion. So, second, at our last meeting, you may recall that I informed the committee that I had received an email from President Penn just prior to the meeting regarding the request we had made on behalf of the committee to amend our charge to include recommendations to the town council regarding zoning enforcement. At the time, I had not had a chance to review that and digest that email. Today, I'd like to give the committee and the members of the public a brief update on the background and status of that request. As quick background, the handout provided to the committee members at the start of our work listed zoning enforcement as one of 5 key zoning topics for the committee's discussion and consideration. In my mind, and I think all or most of the committee members, it seemed clear that zoning enforcement was within the scope of our committee's work. Once we started holding our meetings, we began hearing significant comments from citizens, both in person and via email, about issues and concerns they had with zoning enforcement in our town. As the committee began discussing potential recommendations to the council on zoning enforcement, Attorney Connolly cautioned us that the purpose of the committee approved by the town council did not specifically include zoning enforcement. She stated that we were allowed to talk about zoning enforcement, but were not allowed to make any actual recommendations on the topic to the town council. This seemed strange to me, and I requested further explanation. Subsequently, Attorney Nober sent me an email telling me that the town council's role is only legislative and policymaking, and that zoning enforcement is under the jurisdiction of the town manager, not the town council. She said the only way an expansion to the charge of the committee could be made in order to include recommendations on zoning enforcement would be if it were approved by the town council as a body. At our committee meeting on October 4th, I explained the possibility of requesting an amendment to the committee's charge and requested the committee members' approval to discuss this possibility with President Penn. With a quorum present, there was unanimous approval for me to speak with President Penn about requesting the town council for such an amendment. After several conversations and emails with President Penn, she indicated I had her support in requesting such an amendment. We agreed that the committee would request an amendment to its charge so that it would address zoning enforcement as a second phase of our work and only after we completed our initial charge. I then followed up with 2 emails to Attorneys Nober and Connolly requesting a meeting to discuss the draft wording for an amendment to the committee's charge and the scheduling of a council vote on such an amendment. In response, on October 31st, I received an email from Attorney Nober saying that she would be speaking with the council leadership on how they would like to proceed. The next day, on November 1st, an hour before our last meeting, I received an email from President Penn saying that she had spoken with the legal department and the town manager and requested I stand down on the committee's request for an amendment of our charge. I was asked to have the committee turn over all the evidence we have regarding a lack of enforcement to the town manager and walk away. I was not privy to that conversation and don't know what legal and the town manager may have said or discussed to change President Penn's mind on the request for an amendment to the committee's charge. President Penn has assured me that the town manager and the legal department are more than aware that the committee believes there is an issue with enforcement. She stated that because zoning is not the purview of the town council, she is not inclined to have the council hold a workshop on zoning enforcement. However, she said she will welcome the town manager, the legal department, and the building commissioner to do so if they wish. I want to be clear. I personally admire and support President Penn's leadership and am willing to consider her request to stand down and requesting a change to this committee's charge. However, I want to go on record saying that I respectfully disagree with the decision to exclude zoning enforcement recommendations from the work of this committee. I believe this is a very important issue which has been expressed to the committee by many of the town's residents, and I fear it will be simply brushed aside or ignored by the town. Whether or not this committee ends up addressing zoning enforcement, I ask our committee members who are town councilors to please speak with your council colleagues and do not allow this very important issue to be ignored by the town council and town management. Finally, I've been requested to provide an update on our committee's work to the town council at its meeting next week on November 21st. I'd be happy to hear any comments or thoughts you might have or would like me to include in that update. Thank you. I don't know if anybody has any initial comments on that. Okay. Then we will move to item B, public comment. I want to remind folks that the Zoom link for public comment will close after we complete public comment. The link will be closed, but people can continue to view or watch the meeting on Channel 8 or on the town website. With that, we will open it up to public comment. If you're interested in speaking, please come to the front. Introduce yourself.
How you doing? Eric Schwab, Hyannis. I think it's really unfortunate that the town attorney would recommend to a legislative body or a committee formed partially of legislators to stand down on an issue that's clearly front and center in the minds of the citizens. Without any indication from the town manager or the building commissioner as to what next steps we could expect. I have received 3 emails from the building commissioner regarding neighborhood issues, most recently, and in each one of them, he said he'd get back to me. You'll recall that he spoke here for over 80 minutes, claiming that we as citizens have the right to question his performance and to go, if necessary, to the Zoning Board of Appeals without grievance, and that we had 2 weeks to do so. However, the rules are, at least that I'm aware of, is that we need a letter from him stating that he's not going to do anything, or stating this is what he did and this is all he can do, and I can appeal that letter. Well, that letter hasn't arrived. So the fact that you have a significant non-performance by a member of the town manager's staff, I think is worth looking into. I mean, I think maybe not this committee, but certainly the town council has some responsibility to the lack of performance by a significant member of the town manager's team. So I would like to note, and I appreciate your comments, Mr. Chairman Schulte, regarding this order to stand down, but you need to understand that that has ramifications. It's flowing down to us. We in the neighborhood, we're aggrieved, and our grievances are not being properly attended to by the town manager and by the building commissioner who claim to have authority on this matter. So let it be known that we're still waiting for the building commissioner to get back to us. Thank you very much.
Thank you, Mr. Schwab.
Kind of lengthy, so if you're going to be quick.
I'll follow you. I'll listen to you. Go ahead. Not a problem.
Good afternoon.
Hi. My name is Sharon Lacasse, and I live at 1424 Osterville, West Barnstable Road, in Marston's Mills with my husband, Kenny.
Excuse me, just going to let everyone know, Ms. Lacasse had sent a letter, it's in our packet as well, just so
Yeah,
people realize.
this is
it, just to
pretty
follow
much
up.
the
Yeah.
same thing.
Thank you.
We built our home in 1986, and for 31 years, our neighbor at 1450 Osterville Road was Johnson Tree Farm. Everything was peaceful with our neighbor. In 2016, the property was sold to a builder, landscaping business, and our lives were completely turned upside down. The property, which had failed perk tests for over 31 years, suddenly perked. Even the town of Barnstable looked into purchasing it, and because it was deemed unbuildable, they decided not to pursue it. A septic was installed, and a large barn, garage, and greenhouses were built. We were, of course, concerned that the tree farm was quickly transforming into a full-scale landscaping business. An email from Paul Roma, who was the interim building commissioner at the time, this was in 2017, reads as follows. A neighbor, my husband and I, has complained and is very concerned that you are or will use the farm as a staging area for your landscaping business. As a reminder, that was not part of your plan submission and is not an allowed use in that zone. Totally ignoring this, the property soon became a landscaping business with deliveries of bark mulch and aggregate for resale at all hours of the day and evening. Huge trucks delivering materials and slamming tailgates, some at 4 o'clock in the morning. This is basically right underneath our bedroom window. When my husband approached the town of Barnstable Building Commissioner's office several times and brought up the fact that he felt this was a zoning violation, he was told to fill out a complaint form, but to be advised that if he made one mistake on the form, it would be 3 years before he could file another complaint. So they advised us to hire a lawyer. We couldn't understand why we needed a lawyer for something that was a zoning issue. Isn't that the building commissioner's job, to enforce zoning? We continued to complain, and the noise was unbearable. They continued to tell us to just fill out a form and hire a lawyer. The building commissioner visited the property several times, and nothing was ever done. The misuse of this property continued for many years to get even worse. The owner was issued an agricultural variance to have horses and livestock and submitted the plans for a barn and other outbuildings. This was approved, but never happened. Instead, an industrial sand pit occurred instead. The owner would dump all of his sand and topsoil from his building sites on the property. This went on all day with large vehicles bringing in materials and tailgates slamming until a 40-foot hill of sand was right next to our property. The owner then started an industrial business of processing loam with a huge sifting or screening machine. This machine ran 8 hours a day, Monday through Friday, and the noise made it impossible for us to be outside on our property. We stopped having friends over. In the summer of 2022, we left our house every day because of the noise and would not return until 4:30. If you can imagine rocks rolling in a barrel next to your home all day, every day, it was maddening. Material processing on this property was not used on the property. It was delivered to their landscaping customers. They had pushed this industrial business as close to our property as possible. I don't understand how someone does something like this. He's a noted contractor in town, and he knows better. We asked for help from our town councilor, who approached the building commissioner and was told, "I'm all done with that property." Our neighbor called the building commissioner's office and was told by an employee that the new owner could do whatever he wanted with that property. We were constantly told, "Well, you don't want to file a complaint. Well, you don't want to get a lawyer." Everything was pushed back at us. But we continued to express that this was not just a complaint, that this was a zoning violation. The building commissioner continued to defend the landowner. In an email to my husband and I, he laid out all of our complaints and continued to say that we needed a lawyer and that it would take 3 to 5 years of litigation. We finally did consult with a lawyer, and he said that this was a scare tactic. However, we did meet with Mark Ells, the town manager, and he said it was a good thing that we did not start legal proceedings against the property owner, because then that would mean that town legal department would not be able to proceed. Why were we told to get a lawyer when the town manager then told us that that wouldn't have been a good idea? In 2022, the building commissioner visited the property and finally gave the owner a year to stop the industrial activities and to use the property as a farm. For another year, the sand and rock sifting machine ran every day. Nothing changed. Another year of our peace and tranquility on our property was lost. Finally, in 2023, a notice of zoning ordinance violations and order to cease and desist was issued. The owner was made to pay back taxes as his agricultural exemption was pulled. The owner appealed this decision and asked for many extensions. His lawyer finally reversed the appeal. I believe the owner has 2 years to correct all of the violations. There are 9 in total. And I do have an email from the building commissioner's office stating that we allege that all these things were going on over there. If we allege this, and these things are written in the cease and desist, I just don't understand why it was pushed back at us. The large 40-foot sandhill has mostly been removed. The other large topsoil mound has not. If the building commissioner agreed that there were violations, why had he not done this years prior instead of always trying to put it in our ballpark? We lost 7 years of our lives living next to a property that was always in violation of zoning. Please note also, we have never been notified as abutters of changes on this property because at some time, 2 small slivers of unbuildable land were cut and sold for $1 each between our house and 1450 Osterville Road, and the other between 1450 Osterville Road and Woodside Road, which is the next road heading north. This appears on the plot plan for the property. This made us and Osterville Road no longer abutters. Last month, there was a surveying company on the property. Our fear is that the cease and desist is just a Band-Aid and that the property owner will start back up where he left off. Our goal also is that other people do not have to go through this. We live in a residential area, not an industrial area. When there is an issue of a zoning violation, it should not be pushed back at the abutters and made their responsibility. The town of Barnstable Building Department needs to address these matters themselves and use town legal to solve them if necessary. I have a lot of documentation, as you see. I kind of took over this project because my husband got really sick, and he, unfortunately, All of his illnesses have been caused by our neighbor. The stress can really wreak havoc on your health. And I'm not doing that well either myself, but, so this is one file, and then there's another one just as thick as this. This has been going on since 2016. We're afraid that they're going to come right back into that property again, and they're going to start it right back up. We've spent over $4,000 on legal fees with some help from a lawyer. Our neighbor has helped us pay some of those bills. It doesn't just affect me. It affects the people that live out behind us. It affects the people across the street, and it affects the people on Woodside Road. This is a real problem, and I really feel that somebody looked in the other direction for a number of years and have tried to avoid doing anything over at this property. Thank you very much.
Thank you, Mrs. Lacasse. As you know, I allowed more than the 3 minutes. As the chair, I'm entitled to do so. I met for several hours with the Lacasse. They were kind enough to ask me to their home, and I felt this was a particularly egregious set of circumstances, and I felt she deserved the ability to read that email and describe what they've experienced. So thank you, Mrs. Lacasse. Next. Hello, Mr. Moran.
Hello, Mr. Schulte and Mr. Crow and Ms. Turkelson and Mr. Alsman and Mr. Yeah, I will, just a minute. Let me sign in. I'm Larry Moore, and I live in Katuitt. This committee, and this is not to degrade the other ad hoc committees, but this one is by far the fiesta passante, whatever French word applies. You've done a great job. You've interacted with each other. You've worked together as a group. You've addressed issues that go beyond the limited scope of what was prescribed originally last summer. And the lack of flexibility is alarming. This is not a tribune or a manner in which we started judging other people. It's tempting, but it's not where we go. And I don't even think the town council likes to do that. But in this particular case, my feeling is that the issue at Sandwich basically is enforcement. There may be some other issues, and to be approached that way is an insult to you as a group, and it's unwarranted. When it comes to the fact that you've been told to stand down and to surrender information, this is information that you as a group and with the individual people that appeared before you, you elicited the information from them, you built on it, you developed it, it's your information. If they want to, give them a Xerox copy, but keep what you have. You've done the work, and it may come back to the point that you as a committee or as another group are called upon to deal with that issue. That would be my opinion. Otherwise, it's completely out of line to be approached the way you've been approached. That's my view. Thank you.
Thank you, Mr. Moran. Good afternoon.
Good afternoon. My name is Frank Brady. My name is Frank Brady. I live right next to the Lacasses. I was the other person that called the building department. And I just mentioned to him about what was going on, and the noise it was getting to me. I had enough. I just asked him, could you tone this down? He just listened to me. He never said nothing. I asked him about starting before 7 o'clock. Never said nothing to me. He just says nothing. So finally, I got to the point where he just goes to me and he goes, he owns a business. He has the right to have a business. He can do what he wants. And I said, work on Sundays? Call the police. And that was a conversation between me and our builder inspector. When I got off the phone, I said to my wife, I laughed, I says, he don't work for me. He works for Jacktimer. That property does have water problems. Now, I understand that we're running out of business-owned places in the town, and it's getting harder and harder for people to do business in the town. But anybody shouldn't be able to go and buy a piece of property and then have them try to rezone it when there's building houses all around it, and put them in the middle of something that it's don't, you know, you've heard in other instances that this stuff is happening. When I got off that phone, it's like, what do I do now? I did write a letter to Mr. Els, the manager, supporting what they said and what I felt. Within 2 days, I had people driving up my driveway. I had 400 feet in the woods. Nobody was there before. Nobody comes up there, only the people that either got business to do with me or not. After they left, nobody's been up there. So what was that, intimidation? I should not have to go through this with any department. And then when we had the board meetings with the zoning, this kept on getting kicked down the road. Finally, when they said, well, we'll just drop the appeal for now, but we can bring it back. So I finally stood up and I said, I'd like to ask a question. And they told me to shut up. I mean, I did not shut up, but they told me that, you know, this meeting is closed. I said, I just got no, this meeting is closed. I mean, I don't have money to buy a lawyer and do this stuff. We rely on the people of the town to help us out. And I just hope that, you know, you go over all this zoning and give people the chance. If they have a complaint about it, hear everybody. Let them speak. Let them see what the downside is. I know like I say, we're in a tough position because throughout the whole town, we're running out of zoning areas where we can do businesses. And they got to survive too, just like we do too. But when it affects us the way it did, that's a little bit too much. If he wants to have horses or grow grass for the lawns, let him do that or something. So I appreciate you letting me speak. Thank you.
Great, thank you for your time and sharing your story. Anybody else that would like to speak? Share your name and sign in. Appreciate it. Thank you.
Hi, my name is Chris Gregory. I'm in Centerville. I sent in an email yesterday that might have made it to you.
Yes.
There are a couple questions I had in there that I just wanted to ask here. Hopefully there might be an answer forthcoming. The first is around the apartment buildings that are approved in the Main Street area. I'm interested in if there's a requirement or if there are plans for those buildings to have gray water systems, which would make them far more efficient in terms of water usage than the comparable number of single-family homes. And if that's a policy, it might be a code policy rather than a zoning policy. I don't quite know the difference, but I'm interested in if that's the case or if it can be the case. It seems like that might allay some of the concerns about water usage with some of these developments. The other question I had is around the outer villages in the single-family areas. What are the rules around subdividing parcels at the moment? What's the minimum size if you had an acre that you could divide it into for single-family housing? It seems like a lot of the conflict out there with some of these industrial businesses is that it has kind of the identity of almost a rural suburban area. And we might be growing out of that phase. And would it be a solution to take some of that property and make it so that you could have 4 single-family houses in an acre rather than 1, which I think we average about 1 or 1.5 per acre right now, and kind of try to embrace a more traditional suburban identity out there than a rural identity. Those are basically the 2 questions I had, and you have my comments otherwise. So thank you.
Okay. Thank you, Mr. Gregory. I'm going to ask maybe Jim to respond to a couple of those beforehand. I know, Mr. Gregory, your email came in this morning, so I don't know if everybody had a chance to read it, but I had a chance to read that. I want to thank you for your comments. I thought the comment you had about the gray water, I thought was particularly interesting. I'm curious to learn that myself. Your other comments were about the housing and affordability, and I wanted to let you know that we actually have, from the very beginning, talked to Jim about holding maybe a joint meeting with the LCP as well as the housing. I've had 2 conversations with Rick Presby, who is the housing chair committee, and that is a concern that we have. I know you expressed your dismay at what we have been talking about, but again, the charter of the committee has been the downtown zoning, but we have been trying to address other issues, and I appreciate you bringing them forward. One of the things that I think overlaps is the inclusionary component, currently at 10%, and one of those ways of addressing that affordability would be increasing that from 10, whether it be to 20 or 25% in the new development. So I just want you to know that we have been discussing, I don't know if you've seen any of the other meetings, but that's come up several times. We've talked about that. That is on our list for discussion and some of our subtopics on general zoning, as well as, still working towards perhaps having a joint meeting to talk about some of those issues. So we are very well. I agree with some of your concerns. And again, I thought you had some really good points, and I appreciate you sending your email and sharing and coming here today, because I know you're also working and have a family, so cutting out a little early to do that, it means a lot. So I appreciate you doing that. Thank you. Jim, I'll let you, if you have any answers to Mr. Gregory's questions.
Yes, I can touch on them briefly here.
Okay, one
So, Jim Cupfer, Director of Planning.
Jim, before, we have someone waiting online. They asked if we can do that quick, and then we'll come back to that. So, okay. Cynthia, we'll let you go ahead and bring our online commenter.
IT will bring her over. It's Natalie Pittinger. Good afternoon, Natalie. You have 3 minutes. Go right ahead.
Okay, hi. Sorry, everyone, that I can't be there in person, but wasn't possible today. Just a couple of quick things. First of all, absolutely, I'm appalled at this cease and desist on the enforcement situation. What can that possibly be all about? Anyway, that's one, just my opinion. The second thing is, and I'm glad to see Kristen there, is just about that Strawberry Hill property. I guess whatever it takes to prevent something like that from happening should be on our regulatory books. That's just what I feel. I mean, that as Kristen knows, is clearly a safety issue. And it's about this decrepit house in Strawberry Hill Road, and there was a fence around it, but it's caved in. It's right across the street from a bus stop for school-age children. It's just a total disaster. So I can't imagine how long it's been there like that. And I guess they did get building permits, but maybe building permits should expire and then be renewed after a period of time. Maybe they shouldn't go on forever. And I'm sure there's a big, long story that goes with it. But still, there should be regulations in place so that a situation like that never, ever occurs, in my humble opinion. Okay, that's it. Thanks, folks.
Thank you, Natalie. All right, I don't think we have anyone else on Zoom. I think that's it. All right, we'll go ahead and close the link for Zoom.
I'm sorry,
Mr. Trump?
this just came in, and this is something for the legal staff that's present today to respond to. State law regarding enforcement reads as follows. If the officer or board charged with enforcement of zoning ordinances or bylaws is requested in writing to enforce such ordinances or bylaws against any person allegedly in violation of the same, and such officer or board declines to act, he or she shall notify in writing the party requesting such enforcement of any action or refusal to act and the reasons therefor within the 14 days of receipt of such request. You've heard several speakers today and over the past several weeks who have indicated that this 14-day period is not being respected. The town, the administration of this law is not being performed, so I don't understand how they can tell you to stand down if they're not doing their job. And they're clearly not doing their job as written by the state. So it's a quandary, isn't it? Thank you very much.
Thank you, Mr. Schwab. We'll go back to Jim to answer Mr. Gregory's questions if he can.
Yes, in short, regarding gray water, there is no requirement, and Mr. Gregory is correct, that would be more of a code policy. Direct him to our DPW Town Engineering Office. They have some unique thoughts on how we can better improve our codes and our regulations, but there is, in short, there isn't anything within zoning that impacts that. In terms of lot sizes, that is a really good lengthy conversation we could have in terms of the variation of lot sizes as we sprawl out from east to west. Lot sizes have evolved over time. Really, when development, took hold, the 70s, 80s, 90s, that's when we had, acre or less lot area, and it's progressively gotten larger over time. Much of the town is now 2-acre zoning as part of the Resource Protection Overlay District. So essentially the western part of town is 2-acre zoning now, though if you go out there, you're not going to see many 2 acres because those were all subdivided well in advance of the Resource Protection Overlay District. But in short, if you were to subdivide today in a majority of our community, you would need at least 2 acres to do so.
That was great, Jim. Just a clarification, because in my mind, I think a lot of people hear that 2-acre zoning. The reality is the majority of the property out there has already been subdivided. It would only be for the very large parcels, of which there are.
Yep. There are some,
Yeah.
certainly, but we do get a lot of inquiries from individuals that have, say, 2.5 acres, and I'm sorry, you got 1 acre, or you got 1 lot there because you need a second 2 acres in order to really carve that off again. So yes, that's in general terms. There's a lot out there that were subdivided well before the Resource Protection Overlay District went into place in, I want to say 2000, 2001. But yes, you need 2 acres now.
Okay, great, thank you. All right, any other members of the public with comments? Okay, I think then we'll close public comment, and I'll turn it over to the committee to see if anybody has any comments, responses to the public. Councilor Turkelson.
Thank you, Mr. Chairman. Mr. Brady said something that really hit home for me. He said, we rely on the people of the town to help us out. And I mean, I've been here a year, just coming up on a year. And the struggle for a regular resident who takes this position is you kind of get in this intermediate zone where you are still a resident, but you're connected to this larger entity that brings you information and provides you guidance. But I think we need to remember that the resident is at the top, and the town council is below the resident, and the managerial system is below that. And I hear your story, and it's really heartbreaking because I can't imagine what that would be like. I have a neighbor kind of behind me that's quite loud, and sometimes it drives me nuts, but it's intermittent and episodic, and so you kind of just go to sleep and you hope it goes away. So I'm sorry that you've had such a long struggle, and same to you, Mr. Brady. And I think there needs to be a real kind of it's out in the open now, so we've peeled the scab off. We kind of need to delve into some of these topics. Maybe not this group, but I do think that my fellow counselors are here, and hopefully we've heard what you've said, and that we do keep pushing that forward, because I think that is our responsibility as the resident agent who's representing you, because again, you're at the top, we are here to serve you, and the managerial system is below us. And hopefully we don't forget that when we sit in the seat longer and longer and longer, that we keep that to heart, because I think that's an important connection to maintain. And I think in Mr. Milne's comments, or Mr. Gregory's comments, is interesting, because he basically says some of the things that I think we've been saying, and I think I just said it as well, is, you know, his complaint about what he thinks is noise that's acceptable, or living conditions that would be acceptable to Chairman Schulte might be unacceptable. The human experience is just that. What I think is annoying might be devastating for him. And I think we have to just be, you know, aware that your experience is different than my experience, and each of us has that individuality, but we do have laws in place, and hopefully we respect those laws and we take to heart, and we have processes that work. And hopefully if the processes aren't working, we're here to hopefully push forward, again, a better job to help that be better. Because as you've said, it's not just about your life, it's about hopefully that nobody else will have to go through what you've gone through. But I think, you know, what I think might be unacceptable might be perfectly fine for somebody else. And that's the real rub, is that we sometimes live close together because our lot sizes are small. Sometimes we have 2 or 3 or 4 or 5 acres, and you know, it's not such a big deal. So I think the experience of this town is very wide, and we need to take that into account. But we have rules and processes that I think we should be relying on. And hopefully, like I said, my counselors will take up the charge and keep to task, and not let this just be a one-off that you've come to tell us your story and it just goes away, because I think that would be a real tragedy. So thank you for coming today.
Thank you, Councilor Turkelson. Councilor Bloom.
Again, I'd like to speak to Mr. Brady and the Lacasses. I was at that meeting. You're welcome. I've went to the Lacasses' home a number of months ago, and I just want to say something, that even though you spoke up here for 5 minutes, that 5 minutes, and you pretty much described everything. That 5 minutes is nothing, is just a drop in the bucket of what you folks went through for 5, 6, 7 years. The disruption to your life. And, you know, to the point where you couldn't even go outside. You had to keep your windows closed. That constant, you know, rumbling. And I just want the public to understand that there are some things that we really need to respect in this town, and that is a person's home is their castle, and the businesses, you know, they need to show a little respect for that. And you got nothing, you got no respect at all from that business next door, in my opinion. And you know, nobody should have to go through that. You spent a lot of money on your home. It's a beautiful piece of property. It's you know, and you should have the ability to go out there at any point, and you know, noise happens. You know, I live right here in Hyannis. The jets go overhead and all that kind of stuff. You know, you get used to it. But that kind of thing, that kind of constant disruption to your life, really that's something that's just unacceptable, in my opinion.
Thank you, Councilor Bloom. Mr. Osman.
Yeah, I just want to get a better understanding of what stand down means, okay? I'm assuming that we are still going to listen to people who are concerned about these issues. Is that correct?
That is my understanding. Attorney Connolly, you've said that before, that we're welcome to listen and discuss the this issue.
Okay.
I'm asking the question.
Good evening, through you, Mr. Chairman, to the previous speaker and to yourself. Kate Connolly, Assistant Town Attorney. What I tried to explain at the last meeting was that there is a connection between zoning and zoning enforcement, but the town council's role is to make changes to zoning, to the zoning ordinance itself, and not to zoning enforcement, which is a task that's handled by management. The examples that I gave were somewhat limited, and I can repeat them. During these meetings, we've talked about parking. There were two things, one that President Penn raised and one that I believe Councilor Crowe raised, which was we at one point had a parking regulation that was under the Board of Health, and a court overturned it. So my recommendation was that, and then there was another court case that President Penn raised, which had to do with the overlay district, and a court overturned that parking. So my recommendation was, to the extent that parking is something that could be changed in the ordinance, you could make recommendations about how to change parking as it's written in the ordinance.
Let me just stop you there. We're not asking about what we can make recommendations. The question was, can we discuss zoning? And I believe, I could go back and look on the video, but I think you said we can discuss zoning enforcement issues.
I did say that, but
we are not entitled to make recommendations, is what you said, under the current charge.
you're not authorized to make recommendations.
Correct.
And
And I think
I was
Mr.
corrected,
Alsman asked
if I may just
Sure.
finish, Mr. Chairman. I was corrected about that, and I have not been a party to the meetings with leadership, which means the president and the vice president and the manager and the town attorney. I was not party to those discussions, but that is my understanding, is that there is a definite reason to keep the two things separate. And I believe I'm not familiar with the stand down comment, but I believe you said that the President Penn made that reference, because they are having ongoing communications, and they're coming up with a plan for what to do going forward for this committee, but I don't yet know what that is.
I don't know if that answers your question or not, Ken.
Well,
I'm not sure.
It's a two-part question. So we can certainly listen. And I also, as I understand the last statement, if we found things that in the zoning ordinance that we wanted to amend that would make enforcement easier or clarify enforcement, we could do that. We're not saying anything about enforcement, because enforcement is not only the staff, it goes up through the courts and all that sort of thing. We're not talking about that. We're talking about if we make things clearer in the ordinance with respect to what you can and cannot do in a district, I assume that's something that we can discuss and recommend. Is that correct?
If you wish me to answer that, Mr. Chair. Yes, that's correct, and thank you for reminding me. There was a third example that Councilor Turkelson had raised, and that was making clear what you just said, making the enforcement process clearer. And as one of the commenters stated earlier, reading Chapter 48, Section 7, I believe it was, I've read that to you before, and that is correct. The building commissioner has a certain amount of time in which to act or not act, and then people who are not happy with the decision can appeal to the Zoning Board of Appeals. So there is a process that can be followed there. And if it's helpful to change the zoning ordinance to clarify that, that's the type of thing that the town council, you could make recommendations to the town council, because that has to do with changing the ordinance itself.
Okay. I think that those are the points that I feel very comfortable about addressing. I don't want to get into who's in charge of doing what, but as long as I know what we're expected to do, I think that's where we need to be. So, thank you.
Thank you, Ken. Any other comments? Councilor Crowe.
Thank you, Chairman. I want to address this to the Lacasses, Mr. and Mrs. Lacasse, and Mr. Brady. To say was appalled by this is to be underspeaking, but I'm not surprised. Okay, I've been involved in local government in one way or another in my own village for 25 years now. And one of the things I have a problem with is is enforcement and the total lack of enforcement. We don't enforce here. It's pathetic if non-existent. I've made that clear to the town manager. I've made that clear to other people. If this committee is not charged with enforcement issues, which I thought originally by reading it, zoning includes enforcement. I mean, you say one, it's the other. So I understand been explained to by our town legal staff that this is an administrative issue and goes through the town manager. But I will tell you that that'll be one of my primary jobs going forward, for lack of a better word, is making sure we change our enforcement of zoning. It's gotten out of hand. It's gotten out of hand in everybody's neighborhood. I understand we have not a large amount of places for people to have businesses and to grow, but it's my opinion that if you start a business, part of the cost of doing business is having a place to do business, not in your own home and in somebody else's neighborhood. I've been told that one building manager enforces this part, and this people enforce that part, and all different things, and you get this going from the government. And I'm really adamant in saying that as we go forward this year, I think a number of our counselors will be with me in making this a top issue. You should never have had to go through what you did. I know exactly where that property is. I used to be a delivery driver. I went by it millions of times. I understood the problems with it, not perking, and a couple other issues with that a long time ago. And I saw it being developed. Every resident homeowner has a right to peaceful enjoyment of their own property. I've had that problem on my property. I know people in my neighborhood have that problem, and I live in Ossiville, so it happens everywhere. And one person's right ends at the property line, where the other person's rights begin. And this is something that I don't believe we should give a minute for the town to be not spending effort and time and hiring necessary employees to fix these problems and fix them right away. So I'll promise you that that'll be one of my top. It always has been. One reason I ran for office is because of problems I've had next to my own home and noise ordinance and stuff. In fact, in 2011, I was one of the volunteers that went to Hyannis when they were having problems with properties and overcrowded properties, and we called them problem properties where landlords weren't taking care of their properties. I was one of the first ones that got up and said, you need to do this, and that was one of the 5 topics they went up with. Okay, and they did a lot of good things. I remember the police chief coming a couple years later saying that the 25 identified problem properties had gone down to 1. And that was significant, and significant for the neighbors, because you have your rights. And I think our town has forgotten that, and I plan on making sure they're reminded of it and doing whatever we can to end this home occupation in people's neighborhoods where people are running businesses where they don't have a location to run the business. Now, I know they have problems finding that, and one of the things I'd like to see is we build more contractor base in this town so they have places to go. And there's no excuse for them doing it in a neighborhood. But the fact that we don't have that right now does not give them an excuse to do so. And so that's all I have to say. I promise that a number of us on our council are looking into that, and we've had enough. So I apologize for what you've gone through. I know what it's like.
Thank you, Councilor Crowe. Councilor Turkelson.
Thank you, Mr. Chairman. Just one more thing. Just, we're coming up to consider the tax rate, and, just a statistic that I think we all need to remember is that we're 90% residential in this community, and we have a 10% business base. And I own a business here. I'm also a resident. And, we have definite areas where our business, along 132 and, kind of on the edges of 28. But I do think we really need to think about protecting our residential communities from such things as overgrowth. And if it means tightening up our zoning, I think we need to look at that. I know that's not what we're doing here, but just a thought, because, I'm going to be living next to a 9-acre electrical substation, and I don't really have much to fight against that because the EFSB has their way, but trust me, I'm not happy about a 9-acre electrical substation coming into my residential neighborhood. I feel badly for the people that literally abut those properties, or a 20-acre solar farm. So I think, we really have gotten it wrong in this town when we have larger areas of space that have issues long-term. I mean, I'm sure that there's a way these things get done, which is probably too bad, and maybe there's some improper processes that happen. But again, we need to remember, we're 90% residential here. We really need to be protecting our residential property and the people that live here, because that's the major percentage of how we continue to have this town. So I understand having a earth-moving business is hard to do in the town of Barnstable. Well, maybe that's just not something that should be in the town of Barnstable. Or it should be in other areas where we have sand pits. I don't know, sand pit sharing. I don't really know what the answer is, but it just seems unfair that we're asking residents. Their lives are being impinged upon by a builder who obviously needed a large piece of land to be running his business for his profit while affecting your livability conditions. And I think we've let you down there. So again, I apologize for that.
Thank you. Ken?
Yeah, just a quick question. Comment was made about the abutters and that there was a small strip of land that was created in a 2-acre zone. I just found that interesting.
That's an interesting point. I don't.
You come to the microphone.
I wasn't going to speak.
But you'll do a good job.
No, I won't. Ken Lacasse. We have it on the plot plan that we used to be in a butter direct, and all of a sudden surveyors came in years back when it switched, and all of a sudden we're not in a butter. And the strip of land was sold for $1, and it's between us and him, which made me out of the question of fighting anything that he was to do. And I fought it from the get-go when it didn't perk, and they were trying to put a septic in, and it still didn't perk, even after the septic. They allowed the septic to go in with it's supposed to have 6 feet, and they allowed it with a 4-foot. I'm not, too tactical on that, but after all that time, there's a septic, and it never perked prior. We watched them raise the grade on the whole property, and I won't go further with it because I don't want to set myself up. But they cut a little sliver there's a drainage ditch, and it's about 50 feet wide and 100 feet, maybe 150 feet long to the road to cut me out. A lady that owns it lives in Mattapoisett. Seems to be the same name as the engineers of the septic system. But anyways, I don't know if the engineers of the septic system bought that property, that one piece, to get me out of the deal so they could build and pour us and get the septic. Now, I assume that with all those perks that the Board of Health knew that it wasn't perking, and then all of a sudden it perked. So how that happened, I don't know. And the lady across on Woodside Road has another strip of land. You can see it on the plot plan that is the same. Unbuildable, no size, sold for $1 to the same lady in Mattapoisett, Marion Mattapoisett. Really deceiving, We never knew anything was going on, and then they're building and bringing in construction. And it's not a horse barn, it's a boat storage, which they weren't allowed to have on the property. Property is surrounded by wetlands, 100%. I don't want to go through the departments, but I've been in every department. And I did ask Jim, and he was very helpful, thank you, how that came to be, that piece of property. And how can you subdivide a piece of property that's not buildable, just with a river in it, that's it, to get me out, that's all. So my lawyer said it was legal, but if it's legal, it's a deceiving legal, okay? And the laws should change. So if it's legal, I think we should look into what you can do to make it not legal, that someone comes in and puts a strip around your property and does whatever they want next door to your house. I've had numerous issues because of this, personally. This is the property. GIS, you can't find it unless you go to the GIS survey, which I had to come and get it here, and dig my own way in. We have stacks and stacks and stacks of maps, letters that were basically threatening from the building commissioner that just stalled us for the 5 years, 6, 7 years. First day I met him 8 years ago, I was as upset as I am now, and he said, "Calm down, Mr. Lacasse, you're gonna throw a clot." First time I ever heard that, and since then I have thrown a couple. So, soon after he came to our house in the front yard, and that was all verbal then, so it doesn't matter. Came to our house and held up his phone for the noise, and he said, "Doesn't sound that loud to me." And he also said that he didn't think that they should be doing what they were doing. At one point, he said they have a cease and desist on the property. Everything was verbal, so that didn't happen. So then we decided no more verbal, everything has to be written in communication. So we have stacks of communication and letters from him that when I read them, I cried. I cry easy, sorry, but thought I'd lose my house, thought I'd need a lawyer for 15 years. Everything he put, I can give you all copies of all the letters. It's just stacked, so I don't do it, but every time we got a letter, it was a threat. You allege, you allege, you allege. And go see a lawyer. When we met with Mark Ells, after 5 years, I saw the sifting machine come in and the rocks rolling in the barrel, and that was it. I couldn't do it anymore. I went to Mark Ells, I met him. He was, 2 days later, the cease and desist was in order. 2 days later, after 5 years of struggling. So I thank him for that very much. Now I hope they continue and pursue and watch what's going on over there and build a house, you know? It's not a business. It shouldn't be a business. It should be a farm or horses. That's what it was permitted for. Whatever he's going to try to do next, I don't know. But we have fear of a big building going up or something, and then he'll be having possibly all his, one of the bigger landscape companies on the Cape and construction companies. So all his vehicles will be in and out, and they don't, you know, they're gone first thing in the morning, you know. So we'd like to keep it back to RF1, which is what it is and was never enforced for 5 years. If we didn't go to Mark Ells, they'd still be doing that. The soils that came didn't all come from from his foundations. They came from another large landscape company, and he was accepting all of their overflow. So if they have overflow, they shouldn't, I mean, instead of bringing it there, or where they're bringing it, instead of bringing it to their place and then moving it, they should just bring it where it goes. They're taking it to Harwich or something now. But it was all coming in this yard. So 3 trucks an hour, all day long, dumping that soil, and bulldozers outside my second floor window. So that's all. Thank you.
Thank you.
Thank you, Commissioner
I hope the
Hayes.
town council does something about it, that's all. Set some new rules and, just,
No,
thank you so much.
Thank you both for coming in today. Thank you. Okay.
Any, to follow up, I guess my question was more to the point of the question of abutters. Is that a noticing requirement that we're talking about? When you notify the abutters to property about some change in use, or, I don't know, maybe Jim, you know.
Yeah, without getting into the specifics of this site, in general terms, abutters have many different standing relations. So yes, in terms of noticing, so if, say, it comes to the zoning board for uses being changed that maybe don't align with zoning. That is one thing. The other aspect is standing. So you have different rights, whether you're a direct abutter, whether you're nearby a butter, or if you're not an abutter at all. So there's different aspects of being a direct abutter that come into play, and I do recall pulling up this specific plan to look at that, and yes, they did create non-buildable lots in between their two lots, but I'm not certain for this specific aspect as to why they chose to do so. A&R? I'm not sure.
Well,
But
okay. All right, I guess the part that's confusing to me, my experience has not been that you would have different standing depending on how far away you are, or so notices that I'm familiar with, it would be within everybody within 300 feet or something like that would be notified of something happening, and then it would lead to making some decision based upon a lot of input instead of just the one next door. So I just wanted to clarify.
I appreciate it. I think we're, clearly this committee won't be able to address the specifics of this, but, it's given the LaCasse an opportunity to raise the issue, and I think it's clearly folks are aware of that now. So, Mr. Brady, one more quick comment, then we want to move on to some of the other things here.
The big thing, too, before that property was even clear-cutted, there was a water problem. There's water that comes out around the back, comes out to West Barnstable Road. There's a culvert right at the corner of our driveway. That used to flood out. It used to go across to Mr. Munson's driveway because it was dirt at first. I'd have to go there the next day, sweep up the dirt, put it back over on this side. Eventually, when they clear cut it, I believe there was more water because right from Woodside all the way down to Schubel's Pond, that water heads right down there. And it floods the road. In the winter, they had to put cones out there. They had to sand it because of the ice. And to me, by them doing what they're doing, and I've seen property in Hyann is you're supposed to keep the water on your own property. I don't know if it goes for that, but the second driveway they have nearest to us used to wash out. He fixed it, he put pavement on it, put stones in it, but that driveway used to wash out and come right down alongside the driveway. When the Conservation Commission was called, because he wanted to put a building, the greenhouses, whatever, their council got up and told them there's a water problem there. The town wanted to use that for soccer fields. It was too wet. The head commissioner of the council the Conservation Commission, he just brushed it off and says, the only water problem we have is the runoff from the road. I've walked that property. I imagine Kenny has too. Before the clear cutting, after it rains, it was all water. It's all clay. And that water just flows right down there. Eventually, they put a bigger pipe down there to control the water. But when we had that tornado doing right across the horse farm there, that whole place was flooded. All the way down the road into Munson's, into our driveway, into the front lawns on both of our properties. So that I was really surprised that the council on that didn't do something about it. They just said, there's no water problem. Even the engineer that worked for Jack Timer said, there's no water. There's a ditch in the back, a tree must have fell in it. That was a comment. I sat there and just shook my head. This is crazy. I just wish the residents have people that they can sit down with and they'll listen to them and get something done. And just at least get us, so we can express ourselves and get our frustrations out. I think a lot of people in the town know where the problems are. So, thank you again.
Thank you, Mr. Brady.
Jim, I got a question for you. Is it true that people who are not direct abutters can't sue?
Oh, I'm going to toss that over to Attorney Conley.
That's a good question.
Field promotion, you're an
Is that
attorney
true?
now, too.
Kate?
Kate Connolly, Assistant Town Attorney. Very timely question, because the legislature actually just changed some significant things about the State Zoning Act, and I've drafted a memo, I'm drafting a memo to give to the council before we bring some proposed changes that we're going to have to make to our ordinance. And standing is one of the things they changed. We don't have to change anything about the ordinance with respect to standing. There's only one topic that's going to require some changes, because that part of the ordinance becomes effective on February 2nd of 2025, and anything that we or any other city or town has that's inconsistent will be superseded by the state law. But with respect to standing, they've made it, they've changed a little bit what you need to be able to prove that you're an aggrieved person. But yes, in short answer, typically, in order for somebody to sue a zoning board of appeals, and sometimes their neighbor who might be granted some sort of a permit, they have to have standing. They have to initially prove that they are an abutter or an abutter to an abutter within a certain number of feet. And then they have to prove not only that they're aggrieved, but that they're aggrieved differently than anybody else in the neighborhood. And cases that I've had, plaintiffs will be very careful to make sure, if there's more than one plaintiff, one of them says traffic is going to hurt their property, another one says flooding or something environmental. They have different reasons that they put forward. But the main purpose of, I believe it's called the Affordable Homes Act, these changes that have been made to the State Zoning Act are essentially to make it easier for people to sue. I don't have the specific language in front of me, but you're still going to have to prove some sort of standing in order to sue on a zoning issue.
Okay, so that we don't know if it's direct abutters or it would seem, well, I don't know the facts behind this case other than they've created some interesting lots between their property and the aggrieved here. And maybe that's the reason why they did that. They just wanted to be suspicious.
Yeah, I don't know anything about this specific example,
Okay.
but you do have to have some standing in order to sue.
Okay, but if they're no longer in a butter, they don't have any standing.
We'd have to look at, and actually, all of our statutes for different areas of the law have different definitions of standing. Like for conservation, it's one thing, I believe it's 100 feet. And with zoning, it's 300 feet, but they've got a specific definition for abutters to abutters. So sometimes you have to be the direct abutter, but if it's 300 feet, you can be an abutter to the subject property.
Okay.
So, and I can address that more specifically when I have the statutes in front of me at a later meeting if you want.
Okay, thanks, Kate.
Thank you. Go ahead, Seth.
Kate? just like clarification on what you just explained. So if one property had 4 abutters and all the abutters had the same grievance, would they just be on the same suit to sue?
That's an individual choice, but typically what the court, and this is going to change, and I am going to provide the council with more specific information about how it's going to change. But yeah, typically the case law says, it's not in the statute, it's in case law that says you've got to be aggrieved differently than everybody else in your neighborhood.
Aggrieved differently?
Yeah.
So the same grievance for everyone wouldn't apply in that case?
The past case law, that's how it's been interpreted by courts.
And would abutters to abutters be treated differently if they had the same grievance as the abutters to the target property, to the subject property?
All the abutters would be treated the same in terms of, you've got to show that you're aggrieved differently than everybody else in the neighborhood, as strange as that may sound.
Okay.
That does sound strange. It would seem to me if all the abutters had the same problem, they could have a class action suit, or they all would get in the same suit, and therefore they wouldn't have to say, I have a different grievance. Is that true?
Class actions are not usually.
Well, let's say not class action. That's probably the wrong term. I'm not a lawyer, and unfortunately, I could use being a lawyer the last couple of years. But what I'm saying is that if they're one property, 4 abutters, all the same property, if they all have the same grievance, they could all get together and file a suit under the same grievance, or would they have to have each a different grievance? I assume the same.
Again, we're kind of getting into specifics, but there is environmental laws. You can get a group of 10 people to sue on an issue. Zoning does require the case law, again, not a statute, but the case law, courts interpret it as you've got to show, as an abutter who's aggrieved, you've got to be aggrieved differently and worse than anybody else in your neighborhood so that you can pursue whatever relief it is you're looking to pursue.
Okay, but if they're pursuing it separately, I'm saying if they're pursuing it together, they're all plaintiffs in the suit, or they're all,
Right, even if
what do
they're
they
all
call it?
plaintiffs in the same suit, and I have had cases like that, where, that's why I was explaining, like, they'll typically argue something different for
Wow.
each of them,
Oh, that's crazy. Okay, thanks.
yeah.
A loophole.
And sometimes those cases don't go anywhere, because the one that I'm thinking about, after I finished deposing some of the plaintiffs, they called me to settle the case, so that was the end of that. So, it depends. They've got to have strong arguments, though.
Kate,
Thank you.
Kate, can I ask you a question? I don't know if you have the answer to this question, but where can I get the status of this property, of the property that the Lacases are talking about? Where can I get the straight dope on this thing?
I don't know anything about this specific example, and I don't know if Jim can provide more information just generally about where you would go. But, I mean, you start with a property address. You can go on the assessor's webpage and find out exactly where it's located. But then if you want its zoning history, I'm sure we have.
Well, I'm not interested in necessarily the history of the property as to, where is it now? What committees are involved? What?
No committees at the moment, to my understanding. This was an enforcement issue that was now taken up by the building commissioner. So it would be the building commissioner to reach out to. It was previously in front of the zoning board of appeals, but is not currently.
Okay, thank you.
Okay, thank you. All right, then let's see if any other questions. Why don't we move? Okay, quickly, Ken, we just want to, oh.
I do, but I don't think it pertains to this. I think you're talking about conservation and RDA. There you go. Yeah, so a request for determination of applicability, determining where the wetlands are, essentially. So that's a Conservation Commission process, and that might be what you're talking about in terms of standing and abutters and all that, but that would be a conversation with Conservation, and we could certainly provide that information to you guys if you'd like.
Great, thank you. All right, then why don't we try and move to item D, which was continued discussion of where we were last meeting, talking about some of the issues. And Jim was gonna, there we go. We've got another good presentation for us. Thank you.
All right, good evening, Jim Cupford, Director of Planning. Sorry, we're gonna switch gears here, out of enforcement and into downtown Hyannis. So from our last meeting, if you recall, at our last meeting, we discussed parking ratios and building heights as two of the issues that the committee was looking to take on and discuss potential recommendations to the council. And then after speaking with the chair and also having a great site walk this past weekend, I've added a few other aspects to the presentation, so I thought maybe I would just quickly go back over heights and parking ratios just as a refresher, dive in a little bit into the downtown boundaries, and then I have 3 examples of site plans that have been recently reviewed and approved that I thought we could go over, generally speaking. I already know we've already run in an hour here, so I thought maybe going over it, cursory review, having some dialogue, and then maybe the thought after our initial discussion tonight, maybe start tweaking the memo that we have put together to start building that out a little bit for our next meeting, and we can build on the presentation as well, if that's okay. So, again, we're honing in, we're specifically in downtown Hyannis, and we're looking at the previously approved downtown Hyannis zoning, again, from the West End Rotary to the town of Yarmouth up to the Airport Rotary and down to Nantucket Street just past Bismore Park and the harbor. We're specifically talking about 7 new zoning districts, but more specifically, I think we're really talking about the 2 form-based zoning districts and maybe starting to talk about the downtown neighborhood, and I'll talk a little bit more about what I mean there. The 3 issues that that have been raised predominantly, though there are others, we talked about inclusionary, we talked about design and character, and there's others, but honing in right now for the height of buildings, parking ratio, and district boundaries. When we're talking about the heights of buildings, really, again, what we're talking about, I think, is the downtown Main Street and the downtown Village. So the 2 different shades of purple, because those are the ones that went from 3 stories to 4 stories. The rest of them stayed as they were, meaning the heights as they were from the previous zoning. So that chunk of area is really what we're talking about in terms of heights of buildings. And we might come back to this, and we will come back to, I have a slide, so we will come back to it. The light purple is also, I think, where we want to maybe talk about the district boundaries. And noticeably here, we're already talking about 4 stories at the district boundaries. So maybe that's something we want to consider as recommendations to change as well. The district boundaries, again, the purple, I include the little purple chunk in between the red and yellow where Pleasant Street is to holistically look at the downtown Village area. Again, the district boundaries and talking about maybe scaling it down as we are moving from the center core to the outskirts of downtown Village or the downtown area. And so not just heights, but setbacks as well. And there's some potential opportunities for easy maybe recommendations to adjust both of those. And I'll talk a little bit more about that. Lastly, parking ratios. And these are parking ratios as standards in all districts. So when you find it in the zoning code, it will actually be in the early kind of introductory area of the zoning code that talks about standards in all districts, and in all districts meaning the downtown Hyannis zoning district, not all districts across our community, but just these 7 districts here. So in heights of buildings, we talk about different parts of the building as we construct it to get to a top building height. We have the ground story, upper stories, and total number of stories. With ultimately, if you're going to propose something that is 4 stories, the mandate of at least an 8-foot setback. How it looks, again, in our zoning charts, in the downtown Main Street as well as the downtown Village, so those 2 shades of purple. You see the 3.5 or 4-story max, and with a little footnote, that 1 footnote means that 8-foot setback is required if you're going to do that 4th story. These are this is the building where we decided whether or not we liked it, and half loved it and half did not, as well as Puritans. I added some other context photos that, as I was going through some of the site plans, some number of applications provided some interesting context photos that I thought I would share with the group there. This is all throughout our district, ranging in typology, but all having kind of similar attributes in terms of roof heights as they stagger up and down, and providing a little bit more character, some more than others in the area. So again, as we're talking, I think honing in on these 2 specific districts, you'll see the 3.5 and 4 match in both of those districts. And so if a recommendation were to proceed that this committee wanted to adjust the number of stories, I think that recommendation would be for one or both of these and for the number of stories you sought to recommend. In terms of parking ratios, again, I think we honed in on really the residential aspect of it. We have, as it's drafted today, there's minimum parking standards, so you must provide X amount of parking spaces. Again, right now, as it's drafted, it's 1, or as it is in the zoning ordinance, it is 1 per unit. And if we were to adjust that, again, it would be a recommendation. Likely, so in the DMS, which is, so that chart on the right, you'll see the dark red, the different shades of purple again. If you go down there, you'll see residential, and residential or artist living work per dwelling unit is what DU stands for, and it's one really across the board. So we're talking about changing that chart, residential across the board. If you wanted to adjust the ratio, it would be changing 1 to whatever that ratio may be. We can certainly, again, have more conversation about what that ratio could be. I showed this chart or this map at the last meeting. Again, not meant for it to be an interpretation of utilization in terms of capacity of the parking lots. Really meant to identify that we have a lot of parking in downtown Hyannis, and it's not being used well. And there could be opportunities to better utilize much of that parking. An example, 201 Main Street. So I plopped a little square down where the former Cascade was and future 95 units could be. They do have slightly more than one parking space per unit. But if let's say someone were to lease a unit knowingly coming in and saying, I have one parking space, I'm going to park my one car, but I want another car and I want another parking space, that individual has somewhere along the lines of 500 parking spaces within a stone's throw that they could potentially consider. Again, I say potentially because these are private parking lots that would need to be paid for. As we did our site walk, we noted currently, or I noted at least, I don't want to speak for others, the parking lots were not so full, and the current going rate is $10 a day, so $300 a month for probably 11 months out of the year, 10 months out of the year, and 2 months would likely be higher than that. So that would be your option for a second car if you knowingly needed to go find another spot and you just certainly don't have that spot at 201 Main Street. So the third aspect, district boundaries. So again, the conversation has to date evolved around looking at the outskirts of the downtown Hyannis area and maybe really considering that step-down approach. Right now, again, the purple, as we touched on earlier, is 4 stories or is up to 4 stories allowed. And we've seen a couple examples of projects that have gone to 3, but also have had minimum setbacks in the general area, and maybe we need to reconsider that. So if we're looking at the district boundaries, not a lot of single family, but a lot of structures that have the appearance, at least, of single families. This is down Lewis on the top left. There are some single families there. And then down Cedar over towards our eastern side of the district. Again, some single family, mostly multifamily. And the same could be said for over at Lewis Street, some 2 families and others in that general area. Again, the downtown village limits units only by the number of parking they can provide. So we're talking, again, that 1-to-1. And the heights can go up to 4 stories. With the setbacks, you'll see in there 0 to 15. So 0 minimum, 15 maximum, and 0 side yard setbacks. So again, something that maybe we should consider on the peripheries there. Those being the purple. One thing that I would just food for thought for the commission, we already have the downtown neighborhood district in play. That is the yellow that you'll see there. The downtown neighborhood, if you're looking for a different option for development typologies, it is lower heights. So 3-story max, but there is a height requirement, which is cut off. I apologize, but I believe it's somewhere in the 35. It's from the old zoning, so it's the 3-story, 2.5-story building height. Setbacks are increased, so side yard setbacks, now we're talking 10 foot as opposed to 0. The front setbacks, again, 10-foot minimum as opposed to 0. And it talks about one principal building. So this you'll see again down off of I believe it's School Street and maybe on South Street there was preservation of structures, or at least discussion of preservation of structures, and this talks about just that. You can put up to 4 units, either in new construction, but also you can put 4 units within the current principal building. So it kind of prioritizes preservation, if possible, of some single-family structures. Sorry, we went back one too far. And it also allows for other uses. So in that general area on, say, North Street, there's a lot of offices and stuff like that now. That gives an opportunity to preserve those if they so chose. If a new development were to come in, they could potentially do offices, but it also primarily, the primary use is single building up to 4 unit developments in smaller scale developments. So those are the 3 that we've talked about to date: the height of buildings, parking ratio, district boundaries. What I can do for those 3 is start building out that memo a little bit further, and maybe at a subsequent meeting we can maybe start inserting those variables that we want to insert, whether that's reducing heights or the ratio of parking, et cetera. We could build those out. Before we get into it, I thought maybe I could run through just 3 quick examples of something that things have been permitted. I grabbed 3 just different types of residential developments that have been permitted recently: 1 small, 1 medium, 1 large, and then we could have a conversation from there. So first, zooming in on 28 Barnstable Road. So this is the corner of Barnstable Road and North Street. It was permitted for just 4 infill units at 28 Barnstable Road. So this is the small development. This is the existing conditions. This is currently, I'm sure everyone's gone by it a million times, the boutique and bridal shop. The request was to keep the boutique, renovate the bridal shop into residential, and add a 2nd story right there. So they sought to add that 2nd story. This is the elevation that was provided, and make it the consistent height going across, and ultimately inserting 4 residential units at the site while preserving the boutique on the 1st floor. This is the aerial, a lot of paved surface. So we requested, you can kind of see it, in the front there where the paved parking spots are, to be carved off, and grass to be put in there, and the parking to go behind the building. And they agreed to do that. So that has been permitted. It's small scale infill, really nice reuse of the property for the commercial that was underutilized, inserting for residential and preserving some mixed use there, and also hiding the parking in the back and adding a little bit more green space. Every little bit of green space helps.
Go back to the front view of that.
Yeah, of course.
Okay, go back to the next plan. The elevation.
Okay.
Okay, now go back 1, please.
Back to the last one. Yep.
Okay, now go back 1 more time. Okay, now, okay.
Yep. So yeah.
Jim,
So-
what was the parking on that, Jim? I'm just curious. I know we moved it back. I think it was a great idea.
Yep.
Pull out the street. What did that end up being?
Yeah, so it ended up being, I believe, 9 spaces. So you got 4 plus the commercial. So it ended up essentially two spaces per unit, because you got street parking there, and you got the North Street parking lot across the street for Lash's Boutique that probably has.
And when the business is not operational, I mean, that's available for the residents.
Right, yeah,
okay.
exactly right. Yes?
I'm just looking at the picture. In parking spaces 1 and 2, I thought those were going away.
Yes, so that was the original proposal. We didn't ask for them to redo a
Yeah,
plan.
so they'll end up probably with 7 then total for 4 units. Because if we take, it says here that there's 9. There's 1, 2,
Yes,
3,
okay,
4,
you're right.
5,
Yep,
9. So
7.
we'll end up with 7 for 4 units.
Correct,
And then
apologies.
related to a business being on there as well, but obviously there's people aren't probably there all day. They're just coming and going, so. All right, thank you.
I will have to say that's an attractive design.
Yeah.
Can you
Yeah,
go back to that? I'd like to, you got the dormers, but when the gutters come in at the top, what is that called?
When the gutters come in?
I mean, not the gutters, but you have the dormer, and then at the bottom it goes like this.
Yeah, it really
There's-
it frames the elevation there.
Yeah, I think that's more attractive than a lot of buildings we've seen before.
Is it, just curious, is that a local developer? Who's developing that? Is that
Yeah,
the owner?
the owner of the property, hired a local architect to just, enhance this site. With the new zoning came in, they could do it by right, and it was able to move a little bit
I
quicker.
would agree. It's attractive looking, and, yeah, thank you.
And there's no requirement for affordability because it's 10 units or more requires an affordability component.
That's correct.
And now, is that affordability component something that we could recommend to the council that every project have at least one unit of affordability?
You could. I think the threshold of 10 is there for a reason. So we would want to do a little bit of looking at the performance. How we've done a little bit of analysis of what it costs individuals to provide that affordable unit. You might be able to lower that 10. It would be difficult, say, if someone was to put 4, for them to then put require one affordable in there without some sort of incentive. But we could certainly look at that, lowering it at least.
And are there any other tax incentives that this project is getting in order to do this project?
Not that I'm aware of now.
Okay, thanks.
And I don't want to open up the can of worms on this discussion, but one of the things I'm concerned about is I don't want it to just end up being just a short-term rental property, being an Airbnb factory. So that's another thing as we get into some of the other subtopics. We might want to talk about that. Right now, I don't think there's anything in place that prevents all the housing that goes in on Main Street from just becoming that, so.
Question. So this is the chart that we're looking at right now. Total units per permitted proposals, correct?
Permitted, so those were proposals that, yes, have already gone through the permitting process and have been permitted, though this is maybe a month out of date.
And the elevation site plan that you just showed us, is that with the requirements for parking? That's
correct.
Okay. So do you think or in your own experience and expertise, that if there were no requirements for parking, do you think the plan for this would change, given that there is 4 units?
If there was no requirements, I'm not certain. I mean, this is a unique one where they already have an existing footprint. It's a tight lot. If it was a new build, it might change, but I would say probably not much change for this existing one, because they're not changing that footprint. They're not needing to go into the parking at all. So I would say it probably wouldn't change much.
Okay.
All right, so that was the small infill one. Now we're looking at a redevelopment. We're going to go to 199 Barnstable Road. So we're going down the road towards Airport Rotary. And this one is a redevelopment. So it's an existing site that they're taking down the structure and they're putting in brand new construction, 45 units, 9 affordable units, 5 at 65% AMI, 4 at 80% AMI. You'll say, why is that? That's because they did go through the tax exemption, and during that, there was negotiations for additional affordability. So this is the existing site. This is, the past practice on Barnstable Road was that commercial development, and that's really changing over the course of time. A lot of these businesses are no longer or soon to be no longer, and they're looking for the ability to redevelop their site. I know this specific one, the family no longer wants to pursue the company, so they're redeveloping the site. This is what's proposed. This is downtown Main Street zoning, so this could, by right, have gone to 4 stories, though in discussions with the property owner, it was recommended, and they agreed that it seemed to make more sense to put 3 stories at this location. So that's what they chose to do. Going back to the site, it's kind of a unique site in that, if I got my pointer on this guy up here, So they own this property here, they own this property here, they own this property here. Unfortunately, they do not own this property here. Would have been nice if it was a nice, clean redevelopment, but unfortunately, they do not own this site. In the future, maybe that could join in, but for now, it's this, and that's why you're going to see in the redevelopment, it's you'll see that there. That's an existing business that lives there. So this is what is proposed. Again, 45 units. I would say on the existing conditions, obviously not the greatest visually. Some other aspects of it, though, on Barnstable Road, it's one big wide open curb cut, parking that backs onto Barnstable Road at a lot of times, obviously not being overly maintained in the general area. No real landscaping whatsoever. I was hoping Kathy would be here because this was one where we really kind of pushed them to do more and more landscaping. So I was interested in her opinion on that one. The elevations don't do the landscaping much justice. I do have a landscape plan here. But this is what it would look like from the streetscape of Barnstable Road, trying to create that more pedestrian-friendly corridor. This is what it looks like when we're talking about like 10-foot setbacks. So this is approximately 10-foot setback from the sidewalk or the right-of-way, but the back of the sidewalk is likely the edge of the right-of-way. You know, and let's see. This is part of the landscape plan. I think I have it slightly zoomed in as well. One of the key things for this landscape plan is the visual aspect looking into the site. We felt it was very important to try and, again, the whole intent and purpose of the zoning is to try and screen the parking away from the public. So as you're coming up Barnstable Road, the landscaping gets pretty heavy as your angle looking just to the right of that first building. And, you know, they put a lot of street plantings all along. And same thing with the neighbors. We wanted to make sure that they were, there was privacy there. So there we asked for fencing and landscaping, and they agreed to do that. This is a small private way that's partially owned by the applicant. They did some more streetscape there as well.
Jim, let me ask a quick question. I'm thrilled to see the 10-foot setback. Under the zoning, could they have gone to 0, or they could have?
They absolutely could have, but again, a lot of the architects, once they get in there and we start talking about what the intent is here, most will listen and look at, you know, what makes practical sense. So yeah, the 10-foot makes a world of sense on someone like Barnstable Road where there's a little bit more high speeds, so there's a little bit more noise out there. You want a little bit of setback, you want a little bit of landscaping.
I guess I'll just, you know, you brought this up already before, particularly as we get away from the Main Street area. I would just, you know, suggest to the committee as we go into discussions about what to include, I think the inclusion of some sort of setback on some of these other areas, whether it's in the downtown village areas, that we go, when we go off Main Street, that we start looking at that and making those kind of recommendations for the council to consider, so.
But going back to the original map of the districts or the breakdown, yeah, this falls in the dark purple area.
It's still in the DMS right there. Yep.
Yeah.
It's right there. It's on the
So,
edge.
yeah, so they literally could go, so it'd be hard to say we're gonna allow 0 setbacks in this part of the downstreet Main Street or the downtown Main Street. But if you go one road over, you're still in the same unless you totally change these boundaries. Do you know what I'm saying, Chairman?
Well, so
Like, I get what Bob is saying, is like, along Main Street, we can kind of envision that. But this property is actually still in the downtown Main Street. It's not even like you could say, well, in the downtown village, we want a 10-foot setback, because this actually falls within the downtown Main Street section. So it's really funny, because downtown Main Street has a totally different vibe than Barnstable Road. Is that where we were?
yeah.
Solution for us, Jim?
Pardon?
Do you have a solution for us?
We certainly will have a solution. By the end of this, we will certainly have a solution. I will say, though, the downtown village, to that point where it is purple, not this specific site, I think there are some easy solutions for that. But you're right. Maybe having to carve it up a little bit in the downtown Main Street might be something that we consider. I will say, though, for Barnstable Road, this is one area where we might need wholesale relook at this. It might not be your standard development practices of, you know, with the downtown neighborhood, for instance, preserving single-family structures and putting, you know, a small development here, a small development there. This is kind of a, let's start fresh. You know, we don't have many of those in Barnstable, but this whole corridor needs a fresh look, I think. So it could be a whole new district we create for Barnstable Road if that's something we want to look at.
Jim, can you go back to the site plan? Oh, we're gonna go back to that one you said, right there. What's the middle of that building right in the middle of the two buildings? What is that?
Yep.
Is that the one they didn't own?
That's the one they didn't own. So it's the existing business there. Yeah.
Okay.
Yeah, dentist. Yeah, would have been great if it was all together.
Now, it would also be great if there was a more attractive design to these buildings. I mean, I know what they are. They all look the same, but to me, it's that those are not very visually attractive. I'm not the architect. I wish that maybe you can go back and see if they can. What do you think? Yeah, go ahead.
Slander against architects.
A hard ball.
That's what he studied.
Uh-huh.
No, it's after speaking with the architects for the new library, there's definitely this balance that they have to do between, okay, do you want something that's pretty and progressive and forward-thinking, or do you want a design that's going to appeal to most people's sensibilities? This is the latter. This is more, I would imagine, more safe decision for an architect.
Yeah, I'm not talking Frank Gehry. I'm talking about more like Peter Keating or whatever. Is that just a little bit?
It just depends on the materials.
It just would seem to be there's some cosmetic things that can make that a little bit better, more attractive.
Cosmetically, also, it's the render itself has a lot to do with how you would perceive how pretty something is. If this could be the same exact design with better graphics, and your opinion on it would change.
Yeah, the windows could use a paint job on this thing.
Yeah.
They look like they're rotting.
I like it. I mean, considering how big and bulky these buildings are, I don't know. I kind of like it.
And that brings us to the point of design and character. It's very subjective in nature, and it's always a fun conversation. But yeah, I mean, there's always room for improvement in every design. Personally, I was arguing for shutters, but some people don't like shutters. So there's always little.
Do the uniform design guidelines, would they apply to this property, or is that just on?
They would, not to the same degree as in the historic district,
Okay.
but they would in terms of that's their guiding principles for it. So yes.
So colors, materials, you're right. Hopefully, once they take a look at that and comply.
It would adjust it slightly, but not to a great degree, I would say.
Okay.
Jim?
Okay.
I just want to say thank you for both of these properties here. You did a great job with both of these properties. When I heard that this one right here that we're looking at was not going to be 4 stories, I really appreciate that. Thank you.
Ken?
Yeah, just a couple of thoughts. Does the city have a street tree program or policy?
We don't have a policy, though. We would love to get one in place. I wanted to propose one a long time ago. If you put up a sign, you have to put up a tree. But that didn't go anywhere yet. But we do have a street tree program called Greening Hyannis, and it's state funded. We received a grant, and we are actively planting trees in Hyannis, including this area. So this area specifically, when the new sidewalks go in, love to just one every 10 feet or whatever.
The developer isn't putting in the sidewalks and the street trees and those things?
Developer is required to put in the sidewalks. We, with our program, stated that we'll work in collaboration with them. But we have forest of trees we need to plant in Hyannis. So
Yeah.
that's
I-
an incentive we've been able to grant.
Do you have any sense about what the spacing on the trees are?
For the sidewalks, it'll be the best practices. We'll work with DPW on that, but if you.
I'd
yeah.
be cautious of DPW, but
Understood. We have some good guys out there, but yeah, understood.
because to me, anyway, the rendering seems to be fleshed out with more vegetation, street trees in particular. I don't know how wide the sidewalk is. It only looks to be about 6 feet, maybe 5.
Yeah, I think it's closer to 5.
It's a pretty busy street. I don't know that it needs wider sidewalks, but as soon as you start putting in street trees and my favorite things, street signs, they'll be, all of a sudden you can't walk on a 5-foot sidewalk.
Yep. Yeah, understood. And we're very cognizant of that with ADA compliance and all that, so we'll certainly need to be mindful of that for any trees that are being planted. This stretch has sidewalks on both sides. We've always been looking at the opposite side of the street to do maybe a shared use path or something like that. Though with development currently going this way, maybe we're switching gears, but it's more of a conversation to be had.
I know, for instance, in Marston's Mills, they put the street signs right in the middle of the sidewalks.
Not ideal.
Not cool.
So, all right.
Will there be, or if there's not already, bike lanes on Barnstable Road?
Not at the moment, though that's the conversation we're having on not the side of this project, but on the other side. We're having that discussion about a wholesale streetscape improvement plan for basically from the airport rotary all the way down to entering into downtown Hyannis. It's a big project and probably a lot of money. So, yes, sir.
Jim, these grids in front of the building, I assume those are parking spots?
Yeah, so those are pervious pavers, so it allows for infiltration of stormwater.
Okay, good.
But they are parking lot.
Okay.
Yes.
All right, good.
What is the total parking? This is how many units? 45 units?
45,
did
and I
you
believe
say?
it's 45. Yeah.
And they have 20% affordable housing in this one because they negotiated, right?
Right, so
The 9.
Yeah, 9, almost, yeah, it's 45 units, 9 affordable units.
Great. Okay. All right.
Right, and now we're going to move on
More?
to, we're going to travel over to 201 Main Street. So we're going to leave Barnstable Road and go down Main Street towards the east end where the old Cascade used to be. So this is the bigger development of the three. So this is 95 total units. This is 10 affordable units, so the 10% rule, 65% AMI as required per the inclusionary currently. This is was the existing conditions. Now the buildings are now no longer. You'll see our friend, the bluish gray building behind it. And this is what's proposed there. This is one of two, yes, trying to think, now I'm drawing a blank. I believe just 2 that have proposed 4 stories. This is one of them. Commercial, partially commercial on the first floor, though they did have some like gym space for their residents on the first floor as well. And then residential above, and let's see, and parking behind. You can kind of see it, make it out in the back there. It's podium parking, so there's parking underneath. So the first floor behind this primary structure is all parking. There's no first floor residential in the back there. So this is what it would look like, basically across the street from 200 Main Street, so the town building that's there. That's what it would look like there.
Is that retail down below?
It is mostly retail down below, or partially retail down below, but not all. As I mentioned, a part of it is going to be their lobby / like a gym that they're proposing for their residents.
Okay.
So this is the site plan. So this ends up being more than 1 parking space per unit, but it is a little bit deceiving because this area to the north of the plan is commercial parking as well. So this is grandfathered commercial parking that they've always had at that lot, kind of right next to the old, where the old pool used to be. And so that will still exist. And they have slightly more than one-to-one parking. I want to say it's like 1.2 for this site. Well, those are the three. So this one, I will say, 0 setback, so right on the sidewalk there. So, but matching essentially its neighbor. Not a lot of landscaping, certainly, though the commercial parking area was heavily landscaped, but not where the building is. I will say they did more high-quality features or details on the structure, though it doesn't really show here on the elevations. And that's the third option. Those are the three. That's what, I just wanted to kind of give a kind of diverse look at what the zoning does allow. It ranges dramatically to really infill to, medium scale redevelopment where, in some instances that's needed in town. And then, some of the larger scale redevelopment here right on Main Street. So that's what I got for you today.
Any other questions for Jim? So I guess then your suggestion would be that our next meeting, we would start drilling down a little bit more, maybe coming up with some specific thoughts as to what we want to say for recommendations for parking and setback, and maybe reducing the heights on Main Street or some of the buffering.
Yeah.
Okay.
Yeah, I think that would, if that's what the committee wishes, I thought maybe updating the memo to almost, laying it out so that we could insert some variables, whether that's, increasing, as you were mentioning, maybe from 1 to 1.5 for parking. If we're talking about building heights 4 to 3, I could lay it out in the memo so that you guys could fill in those numbers how you so chose, and we could keep moving from there.
How does everyone feel about that? Does that make sense to you? Yeah. Okay. Why don't we look at that, Jim? And then as far as, I think we can probably get into that pretty quickly. Then what would be some suggestions for the next topic? Do we want, the subtopic, maybe we want to talk about, the affordability provision and the inclusionary? I know you've been going to the housing, and I've gone to and watched some of those. Maybe some thoughts on that, the direction they're headed, some things that we might look at doing there.
Yeah, that's a great opportunity to then maybe bring the two together, because that's an overlapping topic that I think both parties will be addressing. They've already talked about, well, I don't need, there's multiple committee members here from that one, but I do know one of the priorities maybe of consideration is changing up the inclusionary zoning. So yeah, we could certainly have that conversation as the next topic, and maybe that's the right time to bring them in.
Yeah, maybe that would be. John, do you know if, I'm trying to remember, John, and who else is on the housing committee? Are you on that, Charlie? Do you have another meeting scheduled for that in December? Or Jim, do you know? Are you going to that one too?
I am, but I don't have it on. November 25th. Oh, yeah.
November 25th, okay. I'm just thinking maybe, Jim, since you interface with that committee as well, right?
Yep.
Maybe see, and again, whether, we've got a couple of members on our committee that are on that as well, whether we want to ask Mr. Presby to attend as well. Our next meeting, maybe we talk about that. He could give us a little presentation on what they're thinking. That might be a possibility.
Yeah.
Somehow, so that we're interacting. I know that's one of the, I mentioned to Mr. Gregory, that was one of the things that we have talked about and wanted to, get their input as well. So why don't we add that along with looking at the memo, these three topics, then we'll look at the inclusionary as well.
Mm-hmm.
And hopefully that will take us through December, and then in January and February, we can get to the other issues that we have, we've talked about. So I think we have, unless anyone else had any other questions on that, I guess we would go to item E, which we, just to confirm the date of our next meeting, we talked about December 13th. I think, John, you're going to be out on that, is that correct? Yeah. But I think all the other parties were available. So if everyone's okay, we'll keep Friday, December 13th for our next meeting at 3:30. Okay. Item F, looking at your calendars, I'd ask you to look at your calendars for January. We can discuss the next meeting. I asked Sarah, she thought the room would be available, looking at perhaps Friday, January 10th and Friday, January 24th for our 2 January meetings. no need to decide right now, but if you could take a look at that at our next meeting, maybe see if those work for everybody.
I'm wondering if we want to tentatively say yes to those dates until we say no.
Sure, that's,
It's probably easier to put them on.
okay. We'll say,
I mean, it's super easy to take them off.
okay. We'll tentatively say Friday, January 10th, and January 24th, also Friday. Tentatively look at those as our 2 dates for January, and then we'll, yes. Then, item G, approved minutes. I don't know if anybody had a chance to read those. I don't think we got, I'm sorry. Kate?
Mr. Chair, I just wanted to mention, given that you're picking dates, I know that I'm not available to the extent that that matters. January 24th, I'm starting the zoning trial for the town.
Oops. I'm sorry, I didn't catch that.
Can't hear Kate. I don't think that microphone.
Oh, can you turn the mic? Okay.
Oh, thank you, Jim. Sorry, I was just giving you my schedule. If, to the extent that it matters, I know right now I'm not available Friday, January 24th, because I'm starting a zoning trial for the town that day.
Okay. Okay,
Okay.
great, thank you. Okay. Item G, approved minutes. I don't know if anybody had a chance to read them yet. I know we got them. Thank you for getting those out. Cynthia, do we want to make a motion to approve, or would you like to hold off till our next meeting so you have a chance to read and approve, or?
I think the next meeting would be better for me.
Okay, we'll defer the approval of the minutes for November 11th till the next meeting. That leaves us with the final item. Do we have a motion to adjourn? Second? All in favor? Aye. Great. Thank you very much, everybody very much.